My Lord, we are ready, but we have an application to make to regularize our process, my Lord.
Yes, Council, go ahead.
Okay, my Lord, our motion is dated the 19th day of July, 2020. 19th day of July.
July.
Yes, 2022, and it was filed on 20th day of July, 2022.
Yes, go ahead, Council.
My Lord, this motion is brought pursuant to Order 48, Rule 4 of the Federal High Court Civil Procedure Rule.
Can you move in terms? Okay, go ahead.
All right, my Lord, since my learned friends are not opposing, I move in terms, my Lord.
Yes. They have not adopted.
My Lord, this motion is praying for an order of this honorable court granting leave to the first defendant applicant to file and serve each conditional memorandum of appearance and reply to the originating summons and all other court processes out of time. 2, an order deeming the already filed and served. The second prayer, my Lord.
Council, go ahead.
An order deeming the already filed and served the memorandum of conditional appearance, reply to the originating summons, and all other court processes as properly filed and served. And the omnibus prayer, my Lord. Attached to the motion is a 6-paragraph affidavit deposed to by Alhaji Malami. My Lord, we are relying on all the paragraphs. Also, find attached is a memorandum of conditional appearance marked as Exhibit A. We also attach our counter affidavit to the originating summons marked as Exhibit B.
Council, since you're moving in terms, all you need is to adopt your processes. Yes. Anyway, go ahead.
Well guided, my Lord. Well guided, my Lord. We also file a written address in support of our motions. We humbly adopt it as our argument in support of our motions. May you plead, my lords.
Ruling. This honorable court, having gone through the application, the affidavit in support and written address of counsel to the applicant, observed that the first defendant has provided a satisfactory explanation such that will enable it to a favorable exercise of this court's discretion to grant the relief sought. And accordingly, in line with the provisions of Order 6 of the Federal High Court Civil Procedure Rules 2019, and under the inherent jurisdiction of court as preserved by Section 6 of 6A of the 1999 Constitution of the Federal Republic of Nigeria, all the prayers and the motion are granted.
As the court pleases.
As
Yes,
the court pleases.
yes,
Yes. Yes, my lord. May I suggest that the counsel to the second and third defendants should first move their preliminary objection so that we respond then before coming to the substantive application, my lord.
counsel for the second defendant, your response?
Yes, my lord, we are ready with the preliminary objection, my lord. My lord, in opposition to the plaintiff originating summons, we file a notice of preliminary objection. Dated the 12th day of August 2022.
The motion dated 12th August, second defendant.
Yes, my lord, 12th August.
Yes,
Dated 12th August 2022.
counsel, go ahead. Yes,
Yes, my lord. The basis of the preliminary objection, my lord, is stated on the notice of the preliminary objections, and the grounds are also well stated. The notice is supported by a written address, my lord. And we rely on the written address in support of the notice of preliminary objection, and we need to adopt the same. And on the strength thereof, my lord, we will urge the court to dismiss
Yeah.
the case of the plaintiff for lack of locus standi based on the grounds and reasons stated in the written address, my lord.
your last submission, counsel.
My lord, we urge the court, my lord, to grant the objections, sustain the objection, my lord, and dismiss the case of the plaintiff for lack of jurisdiction, for lack of locus standi, my lord, and jurisdiction of the court.
S.
That's our prayer, my Lord.
Yes, my lord. In response to the second and third defendants' notice of preliminary objection, the plaintiff has filed a written address in opposition to the second and third defendants' notice of preliminary objection. My lord, the written address is dated 15th day of August, 2022. And was filed on the 19th day of August, 2022. My lord, we wish to adopt same as our oral argument. In opposing the second and third defendants' notice of preliminary objection. And we urge this honorable court to dismiss same. We urge this honorable court to dismiss same for lacking in merit. And the court should proceed to hear the case to determine the case on its merit. That's our humble submission, my lord. We are most obliged.
Any other?
Well, my lord, I was just amazed because I cannot lay my hands on the response, on the reply to our PO, which has not been served on me, but my attention has been drawn to the fact that it was sent by email. And so, my lord, the plaintiff did not serve us the hard copy, even up to this moment, with the reply to the preliminary objection. I acknowledge receipt of advanced copy, a soft copy, but the hard copy, my lord, has not been served on us.
Is response to your preliminary objection?
Yes, my lord. In any event, my lord, I don't think that will delay the adoption of the written address.
Your submission again?
I said, my lord, that will not delay or postpone the adoption, but I just wanted to be on record that he has not served us with the hard copy of his response to our PO.
My lord, I will object to this because my lord, at the last adjournment, the court ordered that we served the counsel to the second and third defendant via email. And that was exactly what we did. by complying with the order. We applied that the process be served via electronic means, which the court granted and ordered that parties should exchange or should serve the counsel to the second and third defendant via email. And that was exactly what we did, except if counsel has forgotten about the order of the court. Thank you, my lord.
At the last adjourned date, the plaintiff submitted that the two processes are before the court, notice of preliminary objection and the first defendant further and better affidavit. Thereby, therefore, process is not ripe for hearing, and went on to apply for proceedings to be heard virtually at the next adjourned date. Then I gave a ruling to the effect that this honorable court, having listened to the submission and application of all counsel in this matter in the application to adopt the virtual mode with regard to this instant case being FFC/DM/CS/3/2022, the application is granted. The matter is hereby adjourned on the concurrence of counsel to the 12th day of September 2022 for adoption. This honorable court hereby orders all parties to file, serve, and exchange all their processes before the next adjourned date. Your application wasn't so specific that it should be via electronic mail, but notwithstanding, I think it was in the other case. But since all of them are by virtual methods, we assumed that all processes are to be served virtually or through email. Notwithstanding that, the second and third defendant counsel just submitted to court that even though he was served through email, that will not stop the matter to be, to be adopted by counsel. Am I right, Mr. Fika?
Yes, my lord, we can proceed, my lord.
Yes. Yes.
So having adopted, my lord, I think having adopted the preliminary objection and also taking the response of the plaintiff, I think is to proceed to the substantive now. I will suggest that to save our time, my learned friend can start, identify all his processes and adopt them. Then subsequently, my learned friend for the first defendant can equally do the same, identify all his processes and adopt them. Then we now conclude also and adopt, so that we can quickly hasten the processes. My lord has been sitting since morning. I think if it is acceptable to my learned friend, this is the approach to go. My learned friend, Dr. Shamsuddin, can kickstart the process.
Yes, we have no objection, my lord.
Okay, then go ahead, counsel.
Objection.
Before my lord is an originating summons. Before my lord is an originating summons dated and filed on the same first day of June 2022.
Just give me a minute, let me confirm.
Pardon, my lord?
Okay, you say your submission again?
Yes, before my lord is an originating summons.
Yes.
Dated and filed on the first day of June 2022. My lord, the originating summons is brought pursuant to Order 3, Rule 9 of the Federal High Court Civil Procedure Rules 2019. And the said originating summons is seeking for determination of the following question, numbered as number 1 to 3. Number 1 to 3 for determination of the following questions, number 1 to 3. And my lord, upon determination of the said questions, the plaintiff shall be asking for the following reliefs. For the following reliefs as indicated in the paragraph A, B, C, D, E, F, and G. Of the originating summons, my lord. Accompanying same, my lord, is an affidavit of 22 paragraphs, my lord. It's an affidavit of 22 paragraphs.
Yes.
Deposed to by Musa Alhaji Yusuf, the plaintiff in this matter. My lord, accompanying, accompanying same exhibits marked at exhibit YB1, YB2, YB3, YB4, YB5, YB6, 7. And we place reliance, my lord, on all the depositions in the said affidavit. As well as the annexures in support. My lord, in compliance with the rule of this court, the originating summons is accompanied by a written address. Is accompanied by a written address. Just to add, my lord, the exhibits are 8. The exhibits are 8, YB8. I'm very sorry, my lord. We adopt the said written address as our oral argument. in support of our case. And we urge my Lord to resolve the questions raised in favor of the plaintiff. As well as the reliefs being prayed by the plaintiff. That's our submission, my Lord.
Yes.
My Lord, upon service of the process to the defendants, both the defendants, first defendant, second and third defendants, filed their counter affidavits. However, my Lord, only the second and third defendants' counter affidavits that we replied to. In other words, we only replied to the second and third defendants' counter affidavit by filing a further affidavit, my Lord. By filing a further affidavit. Of 7 paragraphs, my Lord. We file a further affidavit of 7 paragraphs. Deposed to by Musa Usman Gadaka Esquire. Deposed to by Musa Usman Gadaka Esquire. One of the counsel at Sahel Chambers. One of the counsel at Sahel Chambers handling the case of the plaintiff. My Lord, the said further affidavit of 7 paragraphs is annexed with 4 annexes marked as Exhibit A, B, C, and D. With 4 annexes, my Lord, marked as Exhibit A, B, C, and D.
Yes.
And is that the further affidavit was filed, dated and filed on the 21st day of July 2022. 21st day of July 2022. And we place reliance on all the depositions therein. As well as the annexes, Further to that, my Lord, the further affidavit is accompanied with a written address dated 21st July 2022.
Your submission again?
A The further affidavit is accompanied by a written address.
Okay.
Yes, it's accompanied by a written address.
Same date?
Dated, yes, dated and filed on the same 21st day of July, 2022.
Yes.
Yes, we wish to adopt same, my lord. We wish to adopt same as our oral argument. In support of the further affidavit. And we urge the court to discountenance their counter affidavit. And to dismiss same for being baseless. Further to this, my lord, that's our submission in respect of the further affidavit. My lord, the second and third defendants, upon being served with our further affidavit, they filed a further counter affidavit. Further and better counter affidavit. Further and better counter affidavit.
Yes.
Yes, in opposition to the said further and better counter affidavit, the plaintiff yes, my lord. Yes, my lord, the plaintiff has filed further and better affidavit. The plaintiff has filed further and better affidavit.
Yes, counsel.
Yes, dated 15th day of August and filed on the 19th August 2022. Has filed further and better affidavit on the 15th day of August and filed on the 19th day of August 2022. My lord, the said further and better affidavit is deposed to by Hassan Saraki Esquire. Hassan S. Saraki Esquire. One of the counsel in handling the case of the plaintiff. My lord, the said further and better affidavit has 5 paragraphs. And we place reliance on all the depositions in the said further and better affidavit. My lord, in support of the said further and better affidavit is a written address. dated 15th August and filed on the 19th day of August 2022. And we wish to adopt same as our oral argument. In support of our further and better affidavit. And we urge my Lord to discountenance the second and third defendants further and better counter affidavits. And we urge my Lord to grant all the reliefs of the plaintiffs. My Lord, more so by way of adumbration, with your kind permission, counsel to the second and third defendants
Yes.
Yes, my Lord, counsel to the second and third defendant was out of time to file the purported further counter affidavit.
Counsel to the applicant. Yes.
Yes, counsel to the second and third defendants was out of time to file his further and better affidavit.
Yes.
And resorted to filing same without the leave of this honorable court. Which made his further and better counter affidavit incompetent. Which made the further and better counter affidavit incompetent before the court.
Yes.
And is contrary to Order 26, Rule 4 of the Federal High Court Civil Procedure Rules 2019.
Contrary to?
Order 26, Rule 4 of the Federal High Court Civil Procedure Rules 2019. Which only stipulates 7 days. Which only stipulates 7 days for the counsel to have filed. And in fact, my Lord, the Federal High Court Pre-Election Practice Direction 2022 stipulates lesser days than 7.
3 days.
And we therefore urge my Lord
Strike.
to dismiss the said further and better counter affidavit of the second and third defendants. And my Lord to grant all the reliefs being sought by the plaintiff. That's our humble submission, my Lord. And we thank you for your precious time. We are most obliged.
Yes.
My Lord, in response to the plaintiff originating summons, the first defendant filed 7-paragraph counter affidavit. Tweeted.
I can't hear you. Can you speak up? Counsel to the third defendant, can you speak up? Mr. Ochai.
I think his network has
The first defendant.
Mr. Ochai.
My Lord. In response to the originating summons, the first defendant filed 7-paragraph affidavit dated the 20th day of July 2022, my Lord.
Dated
20th day of July 2022.
Yes.
And was filed on same day, my Lord.
Who is here? Inform Sally to tell people disrupting this procedure. Get rid of it. Yes. And tell Manstein to get in touch with you. Anyway, go on. Yes, Mr. Ochai, go on.
My Lord, this counter affidavit was deposed to by one Mr. Alhaji Malami. We are relying.
Please behave well and no noise because we are new guys.
Yes.
My Lord, we find attached to the affidavit is an exhibit, mark INEC 1.
Go on, go on. You keep.
In compliance with the this honorable court, we also filed a written address in support of our counter affidavit. My Lord, we adopt it as our own submission in respect of this case. May it please, my Lord.
Yes.
That is submission, my Lord.
Yes, my lord. On the part of the second and third defendant, we responded to the originating summons with the third.
Mr. Ochai. Mute
Yes, my
yourself.
Lord.
Yes, Mr. Fika.
Yes, my lord. My lord, in response to the originating summons of the plaintiff, we filed third defendant's counter affidavit opposing the originating summons that is dated 13th day of July 2022.
Yes.
Supported with exhibits and a written address, my lord. The written address is equally dated the 11th day of July 2022. All of those two documents are the initial response of the second and third defendants to the originating summons.
Counsel, how many exhibits?
Exhibits only one exhibit, my lord, exhibit 1. That's the APC guideline. Only one exhibit, my lord. Exhibit 1.
Yes.
My lord, we wish to adopt the counter affidavit and the written address. And exhibit 1 to oppose the originating summons.
Counsel.
Yes, my lord. My lord, subsequently, the third defendant also filed a further and better affidavit. Of 9 paragraphs on the 12th day of August 2022. With exhibits C1 to C8. C1 to C8. C1 to C19, my lord. C1 to C19. C1 to C19, the exhibits. My lord, we rely on the said counter affidavit that is titled further and better counter affidavits. My lord, we rely on all these documents, my lord, to oppose the application of the plaintiff. My lord, I will quickly wish to make a submission on point of law with the current permission of this court. My first initial response, my lord, is on the response of my learned friend that our father and better affidavit was filed out of time without the leave of this court.
Yes, go ahead.
My lord, we wish to submit, my lord. Gladly, the my lord just referred to a ruling of this court before the commencement of the submission of the plaintiff. There was clearly an indication that all processes were filed with the leave of this court. There was an application for adjournment, and the court ordered parties to exchange pleadings, to exchange processes. In fact, included a gracious order to do so by electronic means. So there will not be any basis to say that any processes of this court, any process of the defendants, of the second and third defendants,
Second and third defendants, like you're having challenges with your network.
order of this court on all adjournment and the court seriously all this court.
Counsel to the second and third defendants, can you hear me? Yes.
Yes, my lord. So,
Counsel
my
to
lord,
the-
all, yes, my lord. So all our processes were filed with the discretion, with the leave, and with the order of this court. So the submission that there were orders or processes filed without basis is out of the ordinary.
Yes,
This is the discretion of this court and is clearly stated in order 22 of the rules of this honorable court. This court has the discretion to allow parties to file processes to file a written address. And that has been covered by the several orders of this court. My lord, in response to the affidavit, to the counter affidavit of the first defendant, we equally file the third defendant further counter affidavit.
in response to
the plaintiff, first defendant, sorry. I don't know. Yes, my lord.
counsel, your submission.
Pardon? Sorry, my lord.
Your submission.
Yes, my lord. My lord, I would draw that submission, my lord. I think it was, I have not come to INEC. That was INEC. That was on INEC counter, my lord. It was, my attention was distracted. Yes, my lord. So that's my first argument on point of law, my lord. My second argument on point of law, my lord, is on the veracity of the further affidavit of the third defendant. The further affidavit of the Further affidavit of the third defendant's counter affidavit opposing the summons dated 13th day of July 2023. Malo, that was the affidavit that was filed by Musa Usman Gadaka. It was a further affidavit for the plaintiff. It was deposed to by one Musa Usman Gadaka, a legal practitioner in the firm of Sahel Chambers. My Lord, we take exception to this affidavit and the other and the second affidavit that was filed by Hassan Turaki, also a legal practitioner in the same firm. My Lord, the basis of our objection to these two affidavits that we will urge this court to discountenance and disregard completely .
Yes.
Is because, Mala, it offends the provisions of the legal practitioners' rules of professional conduct. It offends the provisions of the legal practitioners'
Yes.
rules of professional conduct, my Lord, in section 17, subsection 3 of the said rules that prohibits a lawyer, that prohibits a counsel in a law firm from deposing to a contentious affidavit. My Lord, all the affidavits of the second and third defendants were deposed to by the parties, were deposed to by the defendants themselves. In this instance, my Lord, we have an affidavit coming from a law firm, deposed to by a lawyer in his legal apparel, in a contentious matter, making contentious allegations, on the conduct of the primary elections. We have a legal practitioner making serious allegations, serious assertion of facts that he has no right to do as a legal practitioner because he's not a party in the matter. My Lord, the rules of professional conduct prohibits that, and that has received judicial endorsement in the matter of Akilade vs. INEC, my Lord. Akilade vs. INEC, 2020, 2 Nigerian Wukil Court, part 1754, page 439,
Page,
at page 400, sorry, my Lord.
at 1753.
1754, my Lord, 1754. Part 1754, my Lord.
Yes.
At page 439. Precisely at 448. With the kind permission of this court, I will read. Paragraph 24, rules of the rules of professional conduct. Okay. Paragraph 224 of the rules of professional conduct for legal practitioners 2007 forbids a lawyer from being a witness for his client in a matter that is contentious. The point is so basic and fundamental that the total disregard or lack of it by a lawyer cannot be condoned. Any conduct that is a direct affront or infringement of the express rules of professional conduct can only be disregarded as a conduct unbecoming. In the instance case, the second respondent motion was contentious. The appellants, through one Mubarak Imam who described himself as a legal practitioner in the law firm of Amir Raji and Co., counseled to the appellants file a counter affidavit wherein they joined issues with the second respondent on his objections to ground 14 and 18. The counter affidavit offended rules of paragraph 24 rules of the rules of professional conduct 2007 that forbids a lawyer from being a witness for his client in a matter that is contentious. The appellant's counter affidavit, being so brazenly offensive, was accordingly discontinuous. Malo, this is a Supreme Court decision that forbids a lawyer from deposing to an affidavit. So the two affidavits of the plaintiff that was deposed to by Musa Usman Gadaka and Hassan Saraki, my lord, should be discountenanced, should be disregarded and thrown out for being in violation of the rules of our professional conduct that has received this judicial approval in these two cases.
Yes.
On this same principles, my lord, I will also refer the case, this court, my lord, to another matter, another case, my lord. First Trustees Nigeria Limited.
What's the name of the case?
First Trustees, as in First Bank. First Trustee Nigeria Limited and others. My lord, it was reported in LPELR. It's a 2022 matter, my lord, in LPELR. It's a court of appeal matter, my lord, that was also followed the principles in Akilade versus INEC. The Akilade INEC, my lord, is a Supreme Court decisions that clearly laid down the principles prohibiting a lawyer from deposing to contentious affidavit. A lawyer can depose to an affidavit for motion for extension of time, for leave. But in the contentious matter like this, going into factual situations, the two affidavits of Gadaka and Saraki, my lord, should be discountenanced and disregarded for being offensive to these provisions of the law. On this premises, my lord, these two affidavits are gone, they don't exist, and the whole case of the plaintiff should fall because it has not been proved, my lord. My lord, the emphasis I want to make here, or record, my lord, is the fact that the plaintiff must succeed on the strength of his case. My lord, the plaintiff seeks a declaratory judgment of this court. The plaintiff seeks a declaratory relief from this court. My lord, declaratory judgment and reliefs cannot be given on the weakness. The network is freezing. Is gone.
Sorry. Good evening, Council. My lord is joining back again. Just having network issues. My lord is connecting back. So sorry for the inconvenience.
Hello. Council, can you all hear me? Council, we are muted. Can you hear me?
Yes, my lord, we can
Yes,
hear
my
you.
lord.
Yes, my lord.
At what is called break in transmission. I think there's a problem, network problem. So are you done with your submission? Second and
Yes, my
third
lord.
council.
Yes, my lord. I was on the last lap on the priority of the two counter affidavit from the plaintiff.
Cited a case for Trustees Limited and others, Legalpedia.
Yes, my lord. Yes, my lord. And Akilade versus INEC, my lord. And
Yes.
then we urge the court based on the decision of the Supreme Court and section 20, subsection 4, section 20, subsection 4 of the Rules of Professional Conduct 2007. Allowed to reject the two affidavit of Hassan S. Saraki and Musa Usman Gadaka, because as legal practitioners, they cannot depose to contentious affidavit to represent or replace themselves with the plaintiff. My lord, they cannot replace themselves with the plaintiff in this matter. And these two affidavits, my lord, should be completely disregarded, discontinuance in the determination of this application. Lastly, I was submitting, my lord, that this is a declaratory action by the plaintiff. And the plaintiff must succeed or fail based on the strength of his case. My lord, this is a plaintiff that is before this court who even refused to attach the guidelines and the constitution of his party. This is a plaintiff who is before this court that even refused to attach and annex the guidelines and the constitution of his party. Who, when the defendants wanted to attach and the guidelines and the constitution of the party, was vehemently opposing an attempt to attach the guidelines of the party. My lord, without the guidelines and the constitution of the party, I will wonder how the plaintiff will have even put his case. So my lord, I'm submitting. So my lord, the plaintiff in this action must succeed based on the strength of his case. On these three positions, my lord, we urge the court to dismiss the case of the plaintiff for being unmerited, speculative, and based on reliefs that cannot even be sustained before this court. My lord, the first defendant filed a counter affidavit and attached an exhibit INEG 1 to the said counter affidavit by one Alhaji Malami. My lord, we responded to the said counter affidavit of the first defendant by a further counter affidavit deposed to by the third defendant himself, Honorable Yakubu Suleiman, deposed to by the third defendant himself. Although the affidavit is of 13 paragraphs, supported by Exhibit D1 to D3, supported by Exhibit D1 to D3. My lord, we rely on the counter affidavit, the exhibits, and the written address in support. My lord, there is a comprehensive written address in support of the affidavit, wherein we raise three issues for the determination of the court. My lord, we provided adequate responses through our counter affidavit, that was not controverted by the first defendant. No further affidavit was filed to controvert the documents we attached and the abandonments in the said counter affidavit. That's number one. But my lord, by way of further expatiation, the said counter affidavit of Malam Malami, my lord, is nothing but an opinion and a conclusion that is against the provision of Section 115 of the Evidence Act. And then exhibit INEC 1, my lord, we submitted was uncertified, was an uncertified document from INEC.
Was your submission?
Yes, my lord, our submission, my lord, that the exhibit A1, INEC 1, sorry, my lord, in the affidavit of the first defendant.
Yes.
INEC 1, my lord, is his document exhibit INEC 1, my lord, is an alleged or purported report of an election. Purported report of an election that is not certified, but signed by one Afiniki Ethan, who claims to be an electoral officer, that could not even deposit to the affidavit. The said Afiniki Ethan could not deposit to the affidavit. And one Malami, who could not even be described in the affidavit, but simply Alhaji Malami, of no discretion, no identity, no particulars, of no record, deposing to a contentious matter, to depose to a report of an election by INEC. My lord, that's completely makes the whole affidavit and the documents worthless. And we urge this court, my lord, to disregard the entirety of the affidavit by the said Alhaji Malami and as a bit INEC 1 as worthless documents, my lord. You cannot bring a report of an election that is uncertified. We submitted on the legal standing of a REC who has no capacity to monitor election. A REC, a resident electoral commissioner of a state, has no standing, has no legal capacity to monitor election. Even a resident electoral of a state cannot monitor election in the same manner that a state chapter of a party cannot also conduct an election. Anyone that purposes to conduct election on behalf of INEC must show evidence of delegation of power. My lord, we submit anyone that purposes to conduct election on behalf of the first defendant must show evidence of the delegation of power. On the strength of this, my lord, and the elaborate written address, a response to the INEC counter affidavit, my lord, we urge this court to disregard and throw away exhibit INEC 1 for being incompetent and inadmissible before this court. On the whole, my lord, we urge the court to dismiss the case of the plaintiff for being frivolous and unfounded. We thank my lord for the patience and the opportunity, my lord, to address you virtually. Thank you, my lord.
Yes.
Yes, my lord. In response to the second and third defendants, what I can describe as submission on point of law, or rather purported submission on point of law, we wish to submit, my lord, that the said submission by learned counsel is misconstrued. My Lord, I refer the court to section 115 sub 1 and 2, section 115 sub 1 and 2 of the Evidence Act, which states that every affidavit used in court shall contain only statement of fact and circumstances to which the witness deposes, either from his personal knowledge.
Just read out this, belaboring need. I don't want to, just read it out. And
Okay, my Lord. Okay. Every affidavit used in court shall only contain statement of fact and circumstances to which the witness deposes, either from his personal knowledge or from information which he believes to be true. My Lord, relying on this, I want it to be on record, my Lord, relying on section 115 sub 2 of the Evidence Act. The depositions of Musa Gadaka and Hassan S. Saraki in relation to what they deposed. The depositions of Musa Gadaka and Hassan Saraki Esquire in relation to what they deposed. In relation to what they deposed. Are depositions within their personal knowledge, my Lord?
Counsel. Yes, plaintiff counsel.
Yes, ma'am. Yes, ma'am.
So sorry for the
It's okay, ma'am.
break. Yeah. You are saying the second and third defendant counsel was relying on section 115 Evidence
No.
Act.
No, my lord, the section 115, we are the one citing the section now.
Okay,
We
you
are
are
the one-
in that.
Yes, yes,
Okay.
section 115 sub 2, 1 of the Evidence Act, my lord.
Yes.
Do I have to read it again, my lord?
No, you don't have to.
Okay.
Yes, we are taking.
So, my lord, our submission is that the depositions of Musa Gadaka and Hassan S. Saraki
Yes.
are all facts within their personal knowledge. Are all facts within their personal knowledge.
Yes.
In the course of representing the plaintiff. More so, my lord, the Evidence Act is the principal law. The Evidence Act, my lord, is the principal law in Nigeria that is guiding evidence in Nigeria.
Yes.
And my lord, the said depositions complied with the said provision of section 115 sub 1. And supersedes, and the Evidence Act supersedes the rules of professional conduct. More so, my lord, there are authorities. There are authorities to the effect that evidence, or rather affidavit deposed to by legal practitioner is not invalid. Affidavit deposed to by a legal practitioner is not invalid.
Yes.
We kindly refer, my lord, to the case of Bala versus Dikko. Bala versus Dikko, reported in the year 2013, volume 4, NWLR, part 1343. At page 52, specifically at 60. An affidavit evidence, my lord, affidavit deposed by counsel on behalf of his client cannot be ipso facto be declared invalid. By being deponent, counsel only makes himself prone to enter the witness box and urge to his client in the event the court seeks oral evidence in support of the affidavit. And relying on this, my lord, we urge the court most respectfully to discountenance the submission of counsel to the second and third defendants. And determine the case of the plaintiff from its merits. That's our humble submission, my lord. We are most obliged.
All the submissions have you all moved your applications? I just wanted to confirm.
Yes, my lord. I think, my lord, we have earlier regularized. I think all motions, all pending motions were earlier regularized before the court.
Just like to print out. This honorable court, having listened to all the submissions of the council in their various applications and adumbrations before the court, will adjourn the matter to a date that will be communicated by the court registry for judgment.
As the court pleases.
As the court pleases, my lord.
Ada one, some seorang.
Yes, call the next case.
CSO 2022, Jane Abdulmumin Hussein versus Independent National Electoral Commission, INEC, and two others.
Did you hear the name of the case called?
Abdulmumin Husseini, if you are, is that the one, Malot?
Yes,
Abdulmumin.
Abdulmumin
Yes,
Hussein
Malot.
and two. Representation, please. Dr. Shamsuddin. Dr. Shamsuddin.
Yes, my lord. May it please, my lord. My name is Dr. Shamsuddin Magaji. Appearing with me is my learned colleague, Hassan S. Saraki. Our humble appearance is for the plaintiff.
Yes.
May it please, my lords. My name is G.O. Ochai. My humble appearance is for the first defendant.
Yes.
May it please your lordship, my name is Babadala. We appear for the second and third defendants. My lord, I appear with Adamu Abdullahi, Ahmed Khalil, Ali Mohammed, and MS Dangazimi. My lord, we appear for the second and third defendants.
Yes.
Yes, my lord. The matter is slated to today for adoption, and subject to your overriding convenience and that of my learned colleagues, we are ready.
My lord, we are ready, my lord.
My lord, we are ready. However, we have application to make.
Yes. Go ahead.
All right, my lord, our motion is brought to order 48, Rule 4 of the Federal High Court Civil Procedure Rule, and under the inherent jurisdiction of this honorable court.
When was dated when?
The motion is dated 19th day of July, 2022, and it was filed on the 20th day of July, 2022.
I don't want to hear. Mhm.
19th July.
Yes, my lord, it was 19th July, 2022, and it was filed on the 20th day of July, 2022.
Yes.
My lord, we move in terms and we adopt our written address, and we urge your lordship to grant our applications.
Rule in this honorable court, having gone through the application, the affidavit in support, and written address of counsel to the first defendant. Observe that the third defendant has provided a satisfactory explanation such that will entitle it to a favorable exercise of this court's discretion to grant the relief sought, and accordingly, in line with the provisions of Order 6 of the Federal High Court Civil Procedure Rules 2019, and under the inherent jurisdiction of court as preserved by Section 66A of the 1999 Constitution of the Federal Republic of Nigeria, all the prayers on the motion paper are hereby granted.
As the court pleases.
As a court.
Yes.
Yes, my
Now
lord. May I proceed, my lord?
Go ahead.
Okay.
I thought we would adopt the same. I thought we are going to adopt the same strategy for me to finish with the PO.
Okay. Yes. It's true.
Yes.
It's true.
Yes. My lord, we have a preliminary objection in this matter.
Just a minute.
Thank you.
Your submission was? Mr. Speaker.
Yes, my lord, we have a preliminary objection, my lord. We have a preliminary objection dated the 12th day of August 2022. Supported by a 4-paragraph affidavit deposed to by the third defendant himself.
Deposed to
by the third defendant himself. The third defendant, deposed to by the third defendant. My lord, and attached to the affidavit are Exhibit A, 2A, 2B, and 2C, my lord. 4 exhibits: Exhibit A, 2A, 2B, and 2C, in support of the notice of preliminary objections. My lord, the basis, the notice of the preliminary objection is asking this court to dismiss this matter because the plaintiff lacks the local standard to institute this action. My lord, the basis of the application is found in Section 84, subsection 12 of the Electoral Act 2022. That mandates the plaintiff to resign as a political appointee before contesting. Section 84, section 12 of the Electoral Act. 84:12, my lord, of the Electoral Act. That mandates the plaintiff to resign as a political appointee before participation in the Congress or nomination for a member House of Assembly. And the second ground is the open admission by the plaintiff in his affidavit of non-participation in the primary election. That takes away his local standard. Open admission of the plaintiff of non-participation in the primary elections takes away the local standard of the plaintiff. These are the two grounds, my lord. My lord, we attached the exhibits attached. Exhibit A1, my lord, is the notice of resignation that we clearly analyze in our written address. To say that it's incompetent because a notice of resignation is effective when there is evidence that it was received by your employer. There must be evidence in this instance to show that the Secretary to the Yobe State Government has accepted or acknowledged the receipt of the resignation of the plaintiff. We showed evidence in Exhibit 2A that the plaintiff has been collecting salary 200,000 and he has not refunded 200,000.
My lord, we object to this kind of moving his PO. We are even confused what he is doing actually, whether he is moving his PO or adumbrating, or it's just confusing.
Although the preliminary objection is supported by the affidavits I have earlier indicated, we rely on all the affidavits. We rely on the written address in support of the affidavit. And by way of emphasis, my lord, we say that the affidavit, Exhibit A1, is the purported notice of resignation of the plaintiff that we say has not been received. It's just a matter of explaining to the court what the affidavit is.
If you have
And
it,
then exhibit,
anymore,
my lord,
do you have
my lord,
the submission you are just making, so as not to waste time and drag this issue on and on?
yes, my lord,
Yes.
we rely on the affidavits, my lord.
Yes.
We rely on all the affidavits and the analysis of the affidavit in the written address. And we urge the court, my lord, to sustain the preliminary objection and dismiss the case of the plaintiff.
Yes.
My lord, in opposition to the preliminary objection, the plaintiff filed an affidavit in opposition, deposed to by Hassan Saraki, a legal practitioner.
Counsel, you said, can you repeat your submission again?
Yes, my lord. I said in opposition, we acknowledge the counter affidavit of the plaintiff in opposition to the written address and the PO. We acknowledge the counter affidavit of the plaintiff in opposition to the preliminary objection.
Yes.
The said counter affidavit, my lord, was deposed to by one Hassan Saraki, a legal practitioner in the law firm of Hassan Sahel Chambers. My lord, based on the decision in Akilade vs. INEC, Based on the Supreme Court decision, my lord, Supreme Court decision that bars a lawyer and bars a legal practitioner for deposing to a contentious affidavit, my lord, we urge the court to disregard the affidavit of Hassan Saraki for being offensive, inconsistent with the legal jurisprudence established by the Supreme Court, and also Section 20, subsection 4 of the Rules of Professional Conduct for Legal Practitioners, 2007.
Yes.
This decision in Akilade versus INEC was recently in 2022 re-emphasized in the case of First Trustees Nigeria Limited versus Intels. The decision was recently emphasized, followed, and redefined in the case of First Trustee Nigeria Limited and others versus Intels, Nigeria Limited and others, 2022 LPELR 57087 by the Court of Appeal. Based on that decision of the Supreme Court and the recent decision of the Court of Appeal, we urge you, our Lord, to follow the same decision and disregard the counter affidavit to the preliminary objection and sustain the preliminary objection and dismiss the case of the plaintiff for failure to resign as a political appointee before seeking nomination.
Yes.
That's our prayer, my Lord.
Thank you, my lord. The plaintiff, in response to the notice of preliminary objection filed by the second and third defendants, has filed a 9 paragraphs counter affidavit. Has filed a 9 paragraphs counter affidavit deposed to by Hassan Saraki Esquire. One of the counsels in the law firm handling the plaintiff's case. My lord, the counter affidavit is dated 15th day of August 2022 and was filed on the 19th day of August 2022. We place reliance on all the depositions therein. My lord, the counter affidavit is accompanied with a written address. Filed on the 19th day of August 2022. and we wish to adopt same as our oral argument. In support of the counter affidavit. And we urge my lord most respectfully to dismiss the notice of preliminary objection. The affidavit in its support and the written address. For being a misconception of the law. For being misconception of the law. As well as being baseless and without merit.
Counsel to the plaintiff. Hello?
He's not on scene, my lord. And another one is close by him, who is not responding. I have to take, you have to take excuse. Courtesy demands you take excuse. A lot, I don't understand this kind of attitude because even if it is a virtual proceedings, we are expected to exhibit all the decorum and the ethics of the profession as if you are in physical attendance. A lawyer cannot just dissert speaking before my lord without taking an excuse, my lord. It's really unfortunate.
He was
Really
in,
unfortunate.
as he was submitting, I do not know what happened. He was in the process.
Yeah, he just stood up and left. And someone close to him should have stepped into, if there's any emergency, to tell court that they have emergency and then inform us what we can do.
I cannot see them on the screen. They have disappeared completely.
Yeah, they disappeared and off the network.
And that he called to confirm what is happening. I cannot see the plaintiff's counsel on the screen.
Wallahi mun samu matsala da wannan.
Ni ne na shiga wani waje don yin bidiyo a ranar.